Advanced Medical Directives. Introduction. Advanced directives are instructions you give your doctors telling them what kinds of medical care you do or do not want if you become unable to make medical decisions for yourself. A living will and a durable power of attorney for healthcare are examples of advanced directives. In a living will, you specify the medical care you do or do not want to receive if you become unable to make decisions for yourself. Living wills usually apply to end-of-life situations. In a durable power of attorney for healthcare, you appoint someone to make healthcare decisions for you only when you cannot make the decisions yourself. This tutorial explains advanced healthcare directives. It discusses the living will, the durable power of attorney for healthcare, and other forms of advanced medical directives. The tutorial uses hypothetical situations to explain some topics. It also includes helpful information about choosing forms and getting ready to fill them out. This tutorial is for informational purposes. It reviews the main concepts of advanced directives so you're more informed about the issues. It does not replace the advice of your doctor or lawyer. Advanced directives. The right to give advanced directives is one of the main patient's rights put into law. As a patient, your other rights include the right of informed consent and the right to keep your medical records confidential. As a patient, you are entitled to receive information from your doctor about your illness and the benefits and risks of the treatment options. After understanding your diagnosis, treatment options, and the benefits and risks of the recommended treatment, you have the right to accept or refuse the treatment. This is called informed consent. For invasive treatments, such as surgery, the doctor must have you sign a form indicating that you have been informed about the treatment and consent to it. This is called a signed informed consent. If you refuse the recommended treatment, the doctor may ask you to sign that you have refused treatment. In the question situation, Mark is a terminally ill patient. Many terminally ill patients become unable to make decisions or let their doctors know their wishes as the illness gets worse. If Mark cannot make decisions or communicate and does not have an advanced directive, his doctors have no way of knowing whether or not he wants to stay on the respirator. The best time to write a living will stating which treatments are or are not wanted is while a patient can still make decisions and communicate them. Because it takes effect while you are still living, it is called a living will. It is different from the will you will write to dispose of property, which takes effect only at death. Examples of medical situations where a person can no longer make decisions include being in a permanent coma, also called a permanent vegetative state, losing the ability to think competently, such as after a massive stroke, losing the ability to think and communicate due to severe dementia. Current technology could allow Jane to stay alive in a vegetative state for years. However, would Jane want to live in a vegetative state? If Jane has a living will that states whether she wants to be fed artificially in case she becomes comatose, the doctors will honor that. A living will usually addresses a person's desires regarding health care if he or she becomes terminally ill and is unable to communicate his or her wishes or in a permanent vegetative state. A person who has been given a durable power of attorney for health care, on the other hand, can make health care decisions when the patient is unable to communicate his or her wishes or is unconscious. Advanced directives for health care can be oral. However, written instructions are more clear and enforceable. Oral instructions given to a doctor by a family member or a friend of the patient could be challenged by other friends or family members. Written instructions are much harder to dispute. In medical settings, the term advanced directives refers mostly to written legal documents, such as a living will and the durable power of attorney for health care. Living will. A living will comes into effect while you are still alive but unable to make decisions. It specifies the medical care you do or do not want to receive if you become unable to make decisions for yourself. A simple living will can include a statement such as, "If I should have an incurable or irreversible condition that will cause my death within a relatively short time, or a state of permanent unconsciousness from which to a reasonable degree of certainty there can be no recovery, it is my desire that my life not be prolonged by the administration of life-sustaining procedures." If I am unable to participate in my healthcare decisions, I direct my attending physician to withhold or withdraw life-sustaining procedures that merely prolong the dying process and are not necessary for my freedom or comfort from pain. Many hospitals have a Do Not Resuscitate Order form, also known as DNR order or Allow Natural Death order. In it, a patient can request not to be resuscitated. In addition, a living will can include an order not to resuscitate. In addition to protecting the patient's rights to communicate his or her decisions in advance, a living will removes the burden of making difficult decisions from family and friends. A living will can include a person's wishes regarding resuscitation, life-sustaining procedures, palliative care, and aggressive treatments. However, it cannot cover all medical scenarios. This is why appointing someone to make medical decisions for you when you cannot make them for yourself is important. Some treatments that are not available now may someday become available. The laws in your state may also change. Because of this, you should include all of your wishes in your advance directives, even if the treatments or wishes are not available or legal currently. Doctors who refuse to honor your advance directives are required in many states to make efforts to transfer you to another provider who would comply. Your doctors may not have an obligation to inform you ahead of time whether they would honor your wishes, so ask them. Hospitals and healthcare institutions, on the other hand, are supposed to inform you at the time of admission. Most hospitals and healthcare facilities, such as nursing homes and home healthcare agencies, are required to observe the following patients' rights. Give you a written summary of your healthcare decision-making rights at the time of admission. Ask you if you have advance directives, and document that fact in your medical record. However, it is up to you to give them a copy of your advance directives. Never require that you have or not have advance directives, or discriminate against you based on whether you have them or not. Make the facility's policies available regarding recognizing advance directives. Since some healthcare facilities and providers may not honor certain wishes in advance directives, it is very important for patients and healthcare staff to maintain good communication. You should discuss your wishes with your doctors, understand your treatment options, and find out whether or not they can honor them. DPA for healthcare.